Oh, hey friends, it's me again, Josh Yeager, fiduciary governance czar, taking my dog for a walk in beautiful overcast Santa Barbara, California. Conversation continues that we began a while ago. It may have been just a mile or two that direction, or it may have been hours ago for you. That's the great thing of the World Wide Web. We can engage in conversation without being bound by the constraints of time or space. An unnecessary sidebar, I apologize. So, talked about what's the job of the trustee. Those effectively are the duties of care. Hey, Dodger, we're actually going to go this way now, bud. And then we talked about what is fiduciary governance. Why would we do it? Talked about the office of the trustee. What is the office of the trustee? Who occupies it? We're going to spend a little bit of time on this compliance library that I talked about, and specifically the memos or the record that make up the library. So I've already said each memo is exactly crafted to the duties of care that the trustee has. That presumes that the trustee has taken the time to identify what those duties of care are. As I've said before, it might be as few as 6 or 8 duties of care, might be as many as 18, 20 duties of care. The level of vigor that a trustee brings to this governance process should be calibrated to the size and complexity of the trust. So a little trust with grandma's house in it, and a couple $100,000 in a checking account, and a brokerage account with Merrill Lynch. That doesn't need a lot of governance vigor and oversight. A big giant pension plan, a very significantly funded trust. I'd say a significantly funded trust is, pick a number, $25 million and north. You ought to have a sophisticated, developed governance process in place for a retirement plan, a ERISA plan, foundation endowment, individual trust. All of these are effectively the same things, same duties of care, just the statutes that define those duties of care are a little bit different. So, what do these memos look like? Every one of these memos starts the same way. I'm a trustee of the XYZ trust. And I, as a trustee, have a duty to ... manage the assets prudently, ... consider the liquidity needs of the trust, ... manage the trust consistent with the trust terms, ... diversify the assets of the trust. Whatever the duty that you're writing about is what follows the ... Trustee acknowledges that they have a duty. Then they say the specific location of where that duty is codified is either the trust instrument itself, Grandma's Trust, page 26, section 5, paragraph 11, says that I have this particular duty, or the state statute, California Probate Code, section 16047, says I have this particular duty. Okay, so now we've identified we got a job to do. We can identify where that job is written down. So that's the policy component of these memos. Each of these memos will be organized by a policy, a procedure, and a practice. 3 P's of fiduciary governance. Thank you, Rick, for that little reminder. So, policy is I am a trustee. I have a duty of care. My policy is that I will fulfill my duty of care. Pretty simple, right? You don't need 14 pages of lawyered up words to say what your duty of care is when it's recited in the trust instrument and in the state statute within a couple of sentences. So cut and paste. Dodger, come back here. Sorry. Ne'er-do-well dog. Let's watch him run. This is kind of fun. Come on, Dodger. Touch. Let's go, buddy. Woo! Nice job, horse dog. All right, sorry for the interruption. Got the policy, first P. Procedure. So what am I going to do to demonstrate that I have fulfilled this policy? Let's take an example. A trustee has a duty to act prudently in the administration of the trust and with the care and prudence of a reasonable trustee under similar circumstances. That's California Probate Code 16047. It's an overarching duty of prudence. So what kind of evidence, what procedure do we want to do to demonstrate that we acted prudently? Well, one smart thing that a trustee would do to demonstrate that they would act prudently is develop a fiduciary governance process, right? A trustee that's just fumbling out there trying to do the best they can without knowing what their job description is can hardly be expected or claimed to have fulfilled their duties with excellence, to acted prudently, if they don't even know what their job is. So, policy, I am a trustee. I have a duty to act prudently. That duty is codified either in the trust instrument and or the state statute. Procedure, I have developed a series of governance activities that I will conduct over the next year, one activity per year for each of my 12 key duties of care. And I will maintain a compliance library where these records and work products are stored in the office of the trustee. Remember, the office of the trustee isn't a physical location, it's the stuff of the administration. Okay? So that's what these memos look like. Policy is the statute. Procedure is what I'm going to do. As to the procedure on fair fees, I'm going to consider the fees that I have decided to pay myself versus some reasonable level of compensation for other trustees in similar circumstances. Procedure for risk and return. I've established risk and return objectives and expectations for the trust, and periodically, or more particularly in this case annually, I'm going to measure whether the risk and return from the trust was consistent with my stated objectives. Prudent delegation to an investment manager. I will review the standing of the investment guys at Schwab to make sure that they continue to have the right licensure and that their portfolio is reasonably allocated, blah-de-blah. So each of these duties of care is identified. That's the policy. Policies exactly reflect the statute itself, or the duty. Policy, procedure, here's the thing I'm going to do. The practice is the thing that you did. That's the memorandum. This all goes on a calendar, once a month or once a quarter or with whatever frequency is needed to get through this cycle. Once a year, you go through the cycle. You take all these memos, put them in the compliance library in the office of the trustee. For me, that's just a file folder on my client's computer. Populate those memos. Fold up the file for 2022 like we're doing right now. And move on and do the same dang thing in 2023. Because once you've established the standard of care of this is what a reasonable trustee would do under these circumstances, here are the 12 things that I understand my job to be, you got to keep doing them. You can't just do them in 2022. Say, well, set it and forget it. I did it once and I'm not going to do it again. So my friends, that's what the compliance library is. It's a series of memos that identify policies and procedures and practices that will be executed within the office of the trustee by the current occupant of that office. They get filed away for future use. Actually, we hope that nobody ever reads them. Frankly, the only time that anyone ever reads these memoranda are when someone's ticked at the trustee and wants to know why they did what they did when they did it. You know, there's another time is when this trustee decides to resign or dies. Somebody else occupies the office. It's a real huge blessing and help for the new occupant to be able to have this huge trove of records of why the prior successor trustee did what they did when they did it. So I suppose there's probably two reasons to go through this exercise. One is defensive, to defend yourself against claims of beneficiaries that think you're a knucklehead. The other is offensive, to prepare the next generation of successor trustees to do their job with excellence. Thus ends the video for today. Thanks for joining.